anyone who isn't familiar with the Pennsylvania standards just needs to take a look at my story from 2006. Every even-numbered year, if a Democrat or a Republican candidate wants to run for statewide office, they need no more than 2,000 valid voter signatures in order to qualify for the ballot from across the state. For third-party and independent candidates, it's a number based on a mathematical formula that can get a bit convoluted, essentially 2% of the highest vote getter in the last statewide election. A formula itself that is manipulated from time to time because things like judicial retention elections, despite the fact that they are elections, are not considered in this formula. This past year, for third-party and independent candidates to qualify for the ballot, they needed a minimum number of signatures close to 20,000, about 10 times the amount that the old parties with all their money need. In 2006, the standard was an historic high, and it was a hideous requirement in which third-party candidates were required to get a minimum of 67,070 signatures compared to Democrats and Republicans' 2,000. During that year, I filed nearly 100,000 voter signatures through a very self-sacrificial exercise of raising money, hiring a petition company, and paying various people around the state in order to make sure we not only collected enough valid signatures, but also had a process in place to random sample those pages for validity and integrity. In our final package, we even redlined out over 5,000 signatures that appeared to be invalid on their face. Despite such due diligence, we, as many independent and third-party candidates are, were challenged by very powerful lawyers from the Democratic Party. We have since learned that in order to get the work product that became the challenge against my candidacy, these lawyers had the preliminary work on the challenge done by an army of legislative aides working for the Pennsylvania House Democratic Caucus on state time, receiving their state salaries in state offices using state equipment. Since then, some of those folks have been convicted, some of those folks have entered pleas, some have been indicted and are awaiting trials or plea agreements. In the face of this extraordinary evidence, the state courts refuse to even look at this new data on the serious crimes and the dirty hands that brought the challenge against our candidacy forward. I stand here 4 years later, myself and my attorney Larry Otter, encumbered for $80,000 in legal fees owed to those same attorneys from the law firm of Thorpe, Reed, and Armstrong out of Pittsburgh. That's who they were with at the time of the challenge anyway. Despite the fact that we need to know, what did these lawyers know? When did they know it? Now, those are essentially the two aspects of ballot challenge. One is the disproportionate and unfair manner in which third-party candidates are forced to meet a standard that is even above and beyond all of the wealth, riches, and numbers of the old parties. But secondly, and with regard to those standards, that's where we thank Senator Fulmer for his being willing to introduce legislation that would facilitate third-party and independent candidates better gaining access to the ballot. But the second, and I think more serious issue here, is the corrupted and absolute partisan decisions on the part of state judges and the complete indifference on the part of the appellate court, namely the Pennsylvania Supreme Court, to in any way rebuke, overturn, or at least comment on these kinds of standards. Instead, every attempt to put on record what had happened to gain justice is not only denied, but we are denied our 15 minutes of presenting argument. We get this denial in a one-sentence order with no opinion. And folks, to me, that is the pressing problem. So I call upon the other senators and representatives of goodwill to get behind Senator Fulmer's bill, perhaps introduce companion legislation in the House, and for legislators, lawyers, and judges to start speaking out against these egregious acts against our Constitution here in Pennsylvania, against the Constitution of the United States, and against the legal and judicial professions that many of us hold near and dear. In order to run for United States Senate as a working class person, back in 2001, I retired from a very lucrative and status-filled position with the Luzerne County Family Court. I did so as not to violate my oath of office as a court officer and be partisan while serving the court. And to think that my rights would be jeopardized to the extent that a state-sponsored conspiracy could not only knock us wrongfully from the ballot, but institutionally engage in a campaign of destruction aimed at my livelihood and what little property I have. So for all of the people here that organize this conference, for all of you who continue to stand by us, let it be known that we will not buckle. Since 2006, we have been fighting back against these bullies, long before we heard about Bonus Gate, unabashedly pointing out the legal anomalies that we were subject to. And I think there's a great story for the media to follow and not show the same indifference as the appellate courts. Again, I thank you, and I'll also remind you one more thing in closing, that since 2006, I remained the last candidate to fight a statewide challenge. Just this year, the Tea Party, the Libertarian Party, and the Green Party all qualified candidates for statewide office. All three were challenged either by Democrats or Republicans. In the case of the Greens, our senatorial candidate was actually challenged by Joe Sestak himself. And in each one of those cases, counsel for those challengers threatened those third parties and their candidates with the imposition of $80,000 to $120,000 in legal fees and costs if they dared to defend the integrity of the voters' signatures that they submitted. I say this is wrong. I say that there was a time in the United States of America where our speech and our right to assemble and our right to peaceably run candidates to speak against grievances was something that's cherished. Today it is something that is stomped on, and it's not even done in back rooms. It's done in plain sight, under everybody's nose, and I challenge every one of you in your institutions, whether it's media, whether it's law, whether it's government, whether it's education, law enforcement, etc. Stand up and defend the principles and the honor of those institutions. Don't let them become the stinking waste dump that the Pennsylvania courts have allowed ballot access in Pennsylvania to become.